one of the most critical things that you do with a union is you negotiate. Unions negotiate with management. They sit down, they lay out the conditions, and then they create a thing called a collective bargaining agreement or a contract. So you'll hear about that. And so in some of the different aspects, we talked about the NLRB and about the process whereby you hold an election to certify or decertify a union. So if you have a union already, you can actually have the employees get together, file a petition with the NLRB, actually file to have the union terminated or decertified. So it works both ways. On the certification, you can petition the NLRB if they determine there's enough people, the employees that is representing the employees. Then they go through and they have an election to certify or not certify it to have a union. You can also decertify it. And the process, though, if you do have a union, what happens is the very first step they have is they have a negotiated labor management agreement. It's called a labor contract, a collective bargaining agreement. So you have that, it's multiple different names, but in all, it's a collective bargaining agreement because the union is representing the collective of all the employees and then negotiate on behalf, and it sets the tone and clarifies the term. Now that said, usually a lot of times the union wants to protect itself first. So almost all the time you'll see something about their, yo, we're the only ones allowed to represent these people over here. All the unions are bad, bad, bad. They cannot represent us. It's in the contract. Here it is. That actually is one of the very first things they always do. Here are what you see 11 different items in the agreements. It's going to depend as to how many there really are by the time it's all done. One time I was the chief labor person for a district, and we had 7 different labor contracts. I handled 5 of them, and the college president handled 2 of them. So, and each one had all 11 of these, plus a few more. One of them actually had 22 different articles, but each one of these is a normal article that you're going to see in there. You're going to see management rights. What does the management have to do? And then the union, we're the only union out there. And then they have a security clause. And then you'll have normally something about strikes and lockouts to define the parameters on that. If indeed there's a breakdown in communications and negotiations cease, you have the strike, and the strike would be, and you actually start defining that, or management could do a thing called a lockout. If the contract is expired, the union they feel is not bargaining in good faith, they can lock all the employees out and bring what they call strike breakers in and replace everybody that's inside. It gets to be really ugly when that happens. I have seen it happen. I've seen people outside picketing. I've seen people that are picketing and dropping nails in the driveway to make sure people got flat tires, people with their signs beating on cars, the whole thing. That is out there, and it happens occasionally. So you'll see different aspects like that. There's actually a lot of times a clause in there. If you work for a public employee, the strikes and lockouts, they're actually illegal in most states. So that said, you have a clause there to make certain it is. Number 5, you'll have union activities and responsibilities. What should the union do? There's a thing called grievances that you have in there. And a lot of times the chief steward during the election of the officer with the union has a massive amount of power. In some ways, that chief steward has more power than the president of the union, because that is the person that a lot of supervisors will see. So typically what happens, if you have a grievance and a formal grievance, then the shop steward and the employee will go to the supervisor and they'll present as to how the contract was violated. Sometimes they'll say it was, but they won't identify the article because it wasn't violated. It's just the employee is angry and wants to sit down and get back at the supervisor for whatever reason. And sometimes it's justified, and sometimes it just depends who's listening. It's not. Then you have to have a section on wages, because keep in mind, wages, hours, and working conditions are all required to be bargained with by federal law by either side. So wages. Then you have hours and time off policies. That's usually a big section. Okay, job rights and seniority principles, what's in there, discharge, how you go through the actual termination or discipline of employees, the grievance procedures, and then the employee benefits. Obviously, you'll see in this section over here that there's some really hard areas to talk about. And when you have them out there, the union employees will typically make more than non-union employees. So that said, it's interesting how the private sector has shrunk so much and the public sector has grown so much. a big decision happened in 2018 called Janus versus AFSCME. This was huge, and really some parts of our book are actually antiquated already by this decision. It took place and as it's being implemented across the country. Janus is actually somebody that worked in Illinois, and AFSCME is a gigantic union primarily on the East Coast. AFSCME stands for American Federation of State, County, Municipal Employees. So that's where you get one letter for much. So you have a federation out there, and what they were doing is requiring non-union members to pay fees that they called agency fees. And here's the logic behind it. 100% of the union dues are collected, and unions play an active part in politics. They lobby, they sit down, they lobby for candidates. They tend to always focus in on Democrat-only candidates. So usually there's a strong affiliation there. So AFSCME had the same deal. You had the legal right to drop out of the union and not be a member, but because the union would negotiate and you would benefit from the negotiations in increased wages and benefits, the courts had made a decision that because you benefited, they were entitled to agents fees or fair share fees. It depends who's calling the shots as to what you want to call them. That being said, normally they would be charged about 70 to 80% of what a regular union member would be because they wouldn't negotiate and represent that because they thought that the political aspect was only worth 10 to 20% overall of all the wages. So you have different amounts as to what they would claim was contributors politics. Janus felt that this is not true. So Janus filed against AFSCME to say, I don't want to pay one single dime to AFSCME because no matter what happens, they are political and I don't support them. So therefore, I want to drop out altogether and they can't make me pay. The Supreme Court agreed with Janus, and this shook up the entire world. Really, right to work laws, you'll see there's a map in the book that outlines them in the process. You'll see all that. It's almost irrelevant because of the fact that now, even in California, if you have a shop like we do here, okay, that has union, then you can drop out of the union if you choose to do so. So me as a faculty member, we have a faculty union, and I have a legal right, if I want to drop out, not pay any dues whatsoever. So that's my right, even in California. So we'll talk a little bit more about union membership, but this really put a major stake in the heart of a lot of unions because you had a lot of people dropping out and the union membership dropped even faster after this decision. So let's start talking about the grievance part. If I disagree, or if you have a union member disagreeing, they can file a grievance saying that by the employee that they violated the contract in Article 3, Section 4, Paragraph 5, and they would file that and they would go forward. And usually you'll have the grievance being brought forward by the shop steward. So every division typically has a breakdown. They'll have their own shop steward, and the shop steward is actually a very powerful title, even when there's not a shop. But the shop steward overall has a lot of power because they go with the employee to the supervisor, or sometimes they go to the supervisor and say, hey, before we get too far, this is the first informal step. We want to resolve this. Here's the concern. Why don't you fix this? And so they have that dialogue. A lot of times that actually does work, surprisingly, by having something coming through. But other times it's, nope, I was right, no matter what happens, or the person is so aggrieved, they just want to keep on going for a more formal agreement. You'll see this over here. You'll have this as it goes back and forth on a grievance resolution. The very first step is in the bottom left, the employee grievance. It goes to the shop steward, and the shop steward goes to the supervisory manager. Then it goes up even higher. If the shop steward can't resolve it, then they might have to sit down and file a more formal grievance. So they get out of that informal, they go to formal. So either the shop steward carries it forward, or they have a union representative, a higher level, or a business manager, then file at a higher level. And then you'll have one even higher than that. And then eventually you'll end up at arbitration if it still is unresolved. In our case, our structure in our district is if you have a problem, you file with the shop steward. The shop steward then presents it to the supervisor. That doesn't work, then it goes to the college president. That doesn't work, then it goes to the vice chancellor. That doesn't work, then it goes to the board of trustees. That doesn't work, then it goes up to an arbitrator. Now, there's two terms out there. One's an arbitrator, and one is actually a mediator. First of all, this also applies not just in grievances, but also applies when you're negotiating for that labor management agreement or the collective bargaining agreement or the contract. It's all the same. So you're in that bargaining zone and you don't come to closure on it. If you don't come to closure on the contract, then sometimes you bring in a mediator. A mediator has no power. Put that in your notes. It's important to know that for the class, but it's also important to know in case you ever have dialogue, because mediators do more than just collective bargaining. So sometimes you bring mediators in to help settle arguments between two sides. In this case, mediators have no power, they have no authority. They can encourage, they can cajole, but they can't sit down and force sides to make a decision. Quite frankly, a lot of good things happen out of mediation, and I was a bit surprised. I've been involved in mediation 4 or 5 times. I'm actually a certified mediator myself. So that being said, they go through these techniques to learn. So typically what happens, you go is separate both parties to different rooms and you go, hey, this side over here, they're going to kick you all over the map because your side doesn't hold any water. And then you go in the other room and they say, hey, your side, you're going to lose because the other side, they got these arguments over here. You pretty much tell both sides are going to lose and what their problems are at the argument. It really actually is pretty effective because of the fact that sometimes there's a hot hit on each side, and once you get the emotions out, and sometimes you have the two sides just hating each other personally. Once you sit down and get them outside, sometimes they just calm down. Sometimes you don't. And when they don't, you end up going to arbitration. A lot of times the arbitration language is right in the contract. Also, it depends how far the contract is and how well developed it is. Sometimes you actually name the potential arbitrators. You'll put a list of 10 potential arbitrators right smack dab in the contract. So you'll have that in there. And typically, an arbitrator, they will render a binding decision in a labor decision dispute. So the binding decision, this is this side won over here on this point. This side won over here on this point. This side won over here, and they will sit down and issue an edict as to who's involved. Frankly, it's a pretty good gig. Usually, arbitrators make an awful lot of money. A lot of them are lawyers, the vast bulk of them are, or they could be former labor negotiators in the process. And what they do is they'll sit down and they'll listen to both sides. They'll take a couple weeks, spend lots of hours studying and researching and charging a lot of money. Okay, and then they come up with their decision and they make it. They make a decision for arbitration. Typically, arbitrators, they'll tend to always have a decision-making process that one side likes versus the other side. But a lot of times, a good arbitrator will make a decision for management one time, labor the other time, management another time, and going back and forth because they want both sides to pick them because being the happy medium between the both. So it just depends where that's at. If arbitration is not allowed or the contract still goes forward and nothing is decided, then the contract expires. Then you might see the union having a strike. That means all the employees, they walk off the job and all labor stops. All union employees walk off the job. So then could be a cooling off period where they return to work for a little bit while they dialogue the whole process. You'll see that the union might also do what they call a primary boycott. I just think that's really stupid. And that's the word I use because you're going to boycott the company that you're working for to get people not to buy that product. If you want a job, okay, and eventually these work themselves out, if you do a primary boycott against your own company, and the company goes under, doesn't it seem to be counter? Anyway, so you seldom see a primary boycott because it doesn't make a lot of sense. And then sometimes you even have a secondary boycott. So on the strike, you have that aspect of it. You also have on behalf of the management, you have a lockout where the management just throws them all out and they close the business. What do you mean you closed the business? Okay, well, yeah, we told you that we couldn't afford your contract proposal. So sorry, but they lock the door. Okay, or they bring in strike breakers, and then it really gets ugly. These strike breakers are hired to do the job of the people that are outside picketing, and sometimes it gets really ugly. Or they can go to court directing somebody to return back to work. A lot of times that'll happen for any kind of major area like air traffic controllers, railroads, things that really the we as a nation depend upon, that are a backbone, you'll see that happening too, as well as the public sector. A lot of employees could have an injunction filed against them to stop a strike. Here is a map of the unions. You'll kind of see, believe it or not, California is not the most heavily unionized state. You actually have New York and Kentucky are right up there, but you'll see here's the 50 states in the map as to who has the most union membership. It's rather interesting to take a look at. So know about union elections. Okay, it's called the certification election, or a decert sometimes. Okay, contract negotiations. Have an idea of the different sections of the contract. That will never be on your test, but just the idea of how extensive it can be. Grievances. Okay, a grievance is something where they feel the contract itself has been violated. Know what a strike, lockout, strike breakers are, and know kind of the context of Janus versus ASME. That's a critical thing. It changed the nature of all union negotiations and all management and union relationships whatsoever from that time on forward. Take care.